Good morning. My name is Kelly Trudell. As the Director of Business Development at She and Finney, it's my pleasure to welcome you here this morning. This morning, our program is managing remote workers and avoiding FFCRA COVID-related retaliation. Please check out our website for many upcoming programs on employment law and much more. But first, a few housekeeping items. The program today is being recorded. We will post the audio and all slides later today on our website and LinkedIn. Information on FFCRA credits is also included on the final slide. We encourage you to post questions using the Q&A tab at the bottom of your screen. Questions will be addressed at the end of the presentation. The presenter today is attorney Liz Bailey. Liz has practiced in the area of management side employment law, counseling, and litigation since 1992. Her client base ranges from private corporations to municipalities and counties. Liz works closely with HR professionals, management teams, and in-house counsel to develop effective risk management strategies and cost-effective ways to avoid employment-related problems. Thank you for sharing your morning with us. Liz, the floor is now yours.
Thank you, everyone. And I join Kelly in thanking you for sharing this morning of all mornings with us when many of us have been up late or up early, as the case may be. So thank you for your time. What I'm going to do is to go through a couple of different but interrelated concepts today. And Kelly, Andrea, if you can have the next slide. So my topics today are two different topics, but I think they're interrelated in the sense that as employers in this current time that we find ourselves in, the issue of remote work is now more relevant than ever. And also the issue of retaliation and employment retaliation, which has always been a very significant issue for employers to be aware of, becomes even more pertinent because now we have other issues that come into play concerning the Families First Coronavirus Response Act and COVID-19 related issues in the workplace. So I think this is a timely presentation for employers throughout New Hampshire and New England. And in addition to my presentation, my law partners, Jim Reedy, Mark Ventola, and Karen Whitley, talked on similar topics and touched upon some of these issues in their presentations last week in our reboot of our annual employment law seminar. So those October 29 presentations are available for you on our website, and please feel free to use those resources as well. So remote work. I think we have all read and seen the discussion and the dialogue in the media that employers who might have been skeptical about whether remote work was a good idea or really involved or had the same degree of employee productivity as work in the workplace pre-pandemic are now coming to realize that there are a lot of good things associated with remote work. And obviously remote work in the time of this pandemic has some added benefits in terms of keeping people distanced from one another, keeping people safe, being consistent with guidance or suggestions in the various states' emergency orders. So I'd like to talk for the first part of my presentation about some considerations concerning remote work as employers may be looking to institute remote work as part of COVID-19 safety measures, or now that that's been done, becoming more intrigued by the concept of remote work on an ongoing basis once we find ourselves outside of the pandemic, hopefully sooner rather than later. So some people already have got the jump on this pre-pandemic and they had a remote work policy. Maybe other employers did not because remote work wasn't anything that really lent itself to your place of employment or something that you had encouraged. So I think that now is a great time to be looking at this and asking yourself as an employer, is it time for a new policy? We never had one before, or time to look at what we have and improve upon it. What are some overarching considerations? One thing I think you want to be thinking about, no matter what your policy is that you are giving yourself a lot of flexibility as an employer. What we have seen is that this landscape we find ourselves in changes sometimes from day to day, sometimes from week to week, certainly from month to month. And it's always nice when you can have a policy and you make it, you implement it, you kind of dust off your hands and you say, okay, that's it. My work here is done. I think with a remote work policy that is in part based on your operational needs due to COVID-19 and due to what you are encountering as part of the pandemic and your operations as part of the pandemic, it is great to have, give yourself a degree of flexibility. You want to be sure that your policy sets out that you are going to be able to modify it based on your operational needs and based on evolving COVID-19 best practices. What you may need or want to do today may not be something that you need or want to do in the next 3 months or 6 months or a year. You also want to have flexibility to discontinue your remote work policy if you want to do so and if you think the circumstances warrant. Again, based on considerations about what is the evolving landscape with the pandemic and what are your operational needs. So I think it's important that any policy you implement takes into account as much flexibility as you can for yourselves as the employer. And I'm orienting this, as you can see, from the employer's perspective because we normally work with businesses and employers and help them and advise them. But certainly these concepts are something to be considering no matter what line of industry you come from. Next slide, please. So what are some considerations about remote work arrangements? I talked a little bit about a policy, and I also want to talk about, in addition to a policy, how you may want to have individual agreements with employees that address these considerations that I'm outlining here. A policy is great, and I think you should have it. But it's also a great idea to take the concepts in that policy and tailor them further to the individuals in question who will be remote working. There may be a great deal of overlap, and any sort of agreements that employees would sign off on might contain much the same provisions as your policy. But as you can appreciate, people will have different things that they're doing for the company or for your organization. They will have perhaps different schedules. They will have different expectations about their job responsibilities and about their availability. So it's a great idea if you're trying to bring forward a greater degree of organization to a remote work arrangement, to try to distill those expectations into a document that you and the employee can review and share and be on the same page about. So you avoid misunderstandings, you avoid confusion about what the employee will be doing for you and what the employee won't be doing for you. And I think that all of us who have been reading and trying to keep up with the trends have recognized that a lot of the big businesses out there who have come to embrace remote work, some who never embraced it before, are realizing that this is a good way to go about things. And it's also good to be soliciting employee feedback as well as you're trying to develop policies and think about your remote work arrangements. So what are some considerations? What is your expectation about the employee's work time? It's important, particularly with hourly employees, to be understanding what that expectation is about when they will be working and when they will not be working for you. Mark Ventola had touched upon this last week in his presentation, and that goes to a couple of other issues we'll be talking about, but it goes to when do you think what they should be doing and what hours they should be working so that they are not being overworked, underworked, they are not generating overtime hours that you didn't want. And there's a feeling of some parameters about what the expectations are. When I say locations in terms of remote work, I think there ought to be a discussion about where that person is going to be working within their home, within their off-site location, what that entails for office equipment, and we'll touch upon technology in a second. But have an understanding about what that workspace is supposed to be limited to and look like. For instance, I think that could come up in a couple of different ways. If somebody is down at their refrigerator getting a snack, which can happen when you're working remotely. Are they taking a break? Are they working? The expectation is they're going to be in a certain location while they are performing their work, and you have that understanding with one another about what that's going to look like. What is the work output going to be in terms of your expectations, in terms of theirs? I think that there has been a recognition with a lot of people's individual needs, such as becoming, in addition to an employee, also a stay-at-home parent and a stay-at-home school teacher for kids that are at home being schooled during the pandemic, that sometimes the work hours might not be the same as they had been before, but you still would have an expectation about what is the output, what is the expectation about the outcomes of your work. So perhaps there's a greater flexibility about when work is being done, but you would want to be very clear as an employer that the expectation is that the job is still going to be performed. The outcome is going to be there. Maybe it's delivered slightly differently than if you were in a 8 to 4, 9 to 5 arrangement at your place of business, but those outcomes are still going to be observed and expected. Workplace communications. It's great to understand going into a remote work arrangement what those communications are going to look like, when they're going to occur, how they're going to occur. Are you going to have Zoom meetings to keep in touch? Is it going to be primarily by email? How are you going to get together as a team? Are there going to be periodic communications from the employer about operational updates, about COVID-19 safety issues, about expectations of how the company is doing, about just general morale boosting issues? How do we all, when we're working remotely, not lose the good things about being together as a team? How can we accomplish that? So thinking about those workplace communications and how they will be done and when they will be done are, I think, really important going into it, so that you don't have employees out there who are feeling isolated, who are feeling kind of stranded and without direction, without feedback, without any degree of camaraderie or teamwork. And also from the employer side, you are feeling that we have a good communication going here. If somebody is working remotely, I would expect them to be responsive, just as if they were sitting in the office next to me and I stopped over and said hello and asked them how a project's going. So what are those expectations about the back and forth of smooth communications? What are the expectations about employee availability? And you see that a lot of these concepts have overlaps to them. But I think a good thing about remote work is it gives people greater flexibility perhaps than they otherwise have if they needed to be in an office environment, at a company environment, at an organization within a particular set parameter of time. However, the flip side is that, does that turn into, inadvertently, people never getting away from work because they're always considered to be available because we all know where everybody is, they're working from home. So there has to be, I think, a good balance and a good discussion about what that availability is going to look like, so that employees are being responsive within a time frame that's expected, but employers are also engaging them in a way that is effective and professional and leads to responsiveness and good outcomes, and doesn't lead to burnout, doesn't lead to people being unresponsive because they're never off the clock. That is particularly important, as Mark Ventola discussed last week, when you're talking about hourly employees, because, for instance, if you have an hourly employee, it's going to be very critical, I think, in terms of your operations, that you're managing your overtime issues. You're going to want them to appropriately record their time if they work. You're going to want to be able to monitor that, make sure that you're not seeing kind of mission creep where your overtime expenses become, slowly but surely higher and higher. So you're going to want to have an understanding with them about when they are expected to be available and when they are not available, when they are expected to be off the clock and not respond. That's going to require some discussion with your managers as well, so that they are not emailing employees off of the parameter of hours that you set. They are not engaging them, because if you suffer or permit somebody to work, that needs to be paid. So there needs to be an understanding about what are the boundaries of employee availability. How can we do this professionally? How can we talk with employees to make sure they are getting pre-approval for any overtime, so we're not having that creep up on us? And also, what are the expectations of managers so that they are not engaging hourly employees or employees outside of kind of the parameters of what the expectation had been. With remote workplace arrangements, technology is huge, as we've all experienced. We at She and Finney have been blessed by a wonderful IT team, and I hope you have experienced the same success. But technology is critical as to what technology are remote workers going to be provided with. How are you as the employer going to support their ability to be effective and functioning from a remote setting? What does that look like? What equipment is going to be provided? What are the platforms going to be used? How you are going to be ensuring the security of the information? How you are going to be providing the support to remote workers to make that experience as effective and efficient as possible. Next slide, please. This goes into the confidentiality of information. That's something to be thinking about. And I'm sure in any remote work setting prior to the pandemic, or certainly now, you have been thinking about this issue pretty critically. It goes into the technology that you provide. How can we maintain the confidentiality of information and make sure that our technology systems enable us to continue to do that? And what is the expectation of you as the employer concerning the confidentiality of information? I mean, certainly if you would in no way expect your confidential business information inside the four walls of your company would be compromised, you likewise are expecting that that confidentiality will not be compromised because of a remote work arrangement. So it's a great time to be educating employees, reminding employees of their obligations. Some people may have signed confidentiality non-disclosure agreements as part of their normal employment. I would wager that most of you have confidentiality policies in place to safeguard the confidentiality of your information. So this is a great retraining or reminder opportunity for people if they are going into a remote work arrangement to talk about those expectations again, to refresh them about what documents are out there that they're expected to abide by. Other considerations are wage and hour compliance, as I've already discussed. It's going to be very critical that employees are keeping track of their time. The hourly employees, that's something that needs to be done. But understanding when employees are working, when are they not? For instance, it will be important even for salaried employees if they needed to take a vacation day, if they needed to take some PTO, to make sure that there is a recording going on in terms of the time worked or not worked, so that you can keep track of that time appropriately and credit it against PTO banks, or make sure for hourly employees, they are in fact being paid appropriately for hours worked and for overtime. And lastly, some other considerations are workers' compensation issues. It's critical that if you're keeping a safe workplace for your employees, if somebody had a workplace-related injury, just as if they were at your site of employment or off-site at another business setting, the fact that they're working remotely doesn't change the fact that those injuries should be promptly reported so that you can take steps necessary to report to the appropriate state agencies, or to make sure that you put your workers' comp carrier on notice. And this will be where some of the work you're going to be doing in your remote work policy and in your remote work agreements with employees will come in good stead for you, because there will be discussions that you will have in your policy or in your agreements about essentially what are the working arrangements, so you can determine better, did something happen when somebody was working, or did something happen when somebody was on their own time, in their home, getting the Diet Coke from the fridge versus being in their home office or being in their work area doing work for the company. Next slide, please. Flexible work arrangements. This is not the same as remote work, but I think it does, talking about the flexibility factor of what you're trying to do as an employer in this new and changing environment we find ourselves in, not to lose sight of flexible work arrangements as maybe being an option. Maybe somebody is working remotely on a hybrid basis, but coming into the office for particular reasons, or coming into the company for particular reasons. Maybe you have an arrangement with somebody where their normal work hours are changed due to their personal needs, due to their considerations with maybe childcare, maybe closure of schools or closures of daycares. Maybe just because it's a better system in place, because it allows you as the employer to have less people on site at any given time, and helps you with issues like social distancing, disinfecting the facility, those sorts of issues where you're trying to put into play your COVID-19 compliance and safeguards. It might help to have less people on site at any given time, and flexible work arrangements may be a big help for you in that regard. And it may improve employee morale a lot to know that you as the employer are helping an employee work just as hard for you, but in a different way. Next slide. So now I'd like to turn to the second part of the program, which is the Families First Coronavirus Response Act retaliation issues. And I'm going to really focus on retaliation for purposes of this discussion, but I'm going to just go through a couple of quick points which are available to you in our other presentations we have done, and also on our COVID-19 resource site. We've got a lot of good information about Families First Coronavirus Response Act, and that's been the subject of several articles by members of our She and Finney team. So I'm going to get to retaliation pretty quickly here, but just quickly, some great resources that you are probably aware of, but if you haven't been using regularly, they're a great thing to return to, are the USDOL has published and periodically updates sometimes with fanfare, sometimes without, the link to the regulations themselves and the link to frequently asked questions about the FFCRA. And I just gave you a site to the frequently asked questions, and great resource. They have these sorts of issues broken down by the FMLA, by the FLSA, and also by these frequently asked questions. So wonderful resource if you have kind of a thorny question you're trying to get through. What you're going to find with the frequently asked questions and answers is there is a great degree of pretty granular detail for you for many of the common questions that you would have. And those are updated. So it's a great thing that they will be refreshed. You can return to them as much as you would like. Next slide. So I think most of us are aware there's two types of leave available. There is paid sick leave, and there's 6 reasons, which I'm going to have in the next 2 slides. And then there's expanded family medical leave for the care of the child due to school closure, daycare closure because of COVID-19. So we had a little bit of a respite over the summer where there wasn't a school issue, but there might have been summer camp issues or other daycare issues that were impacting expanded family medical leave. But these leaves remain available. They're sunsetted for the time being on December 31st of this year. We don't know what will happen as we near the end of the year, if there's going to be some expansion of the FFCRA. So we'll all need to stay closely tuned to that. But for right now, at least, we have until December 31st for these 2 types of leave. Next slide. And as you are familiar with, there are 6 reasons. I'm not going to read them here, but they are essentially The first three really deal with the employee being sick themselves. And the next slides. And the next three deal with other situations, such as the employee caring for a person who's subject to the same restrictions as items 1 through 3 above, or you have the employee caring for the employee's son or daughter, as those terms are defined, due to closures of the school, place of care, and there's not another care provider that's available due to COVID-19 issues. The sixth item remains nebulous, to say the least. So the real discussion has been on items 1 through 5 when you're dealing with FFCRA issues. Next slide. Some FFCRA considerations that we have discussed in the past, including Karen Whitley in some of her presentations, is something to think about as you're going through the FFCRA. And it's great to have these considerations, some of them in advance. If you have some time to really sit down and think about it, if you have, I hope it's true for you all, you've had the luxury where somebody has, you've got a workforce that is healthy, that is well, that this has not come up. That would be a wonderful situation to be in. But to take a look at your own organization to ensure you are a covered employer, which small employers generally would be, to see if you're exempt from the FFCRA. If you're looking at an employee coming to you with FFCRA, a request or a need, to sit down and try to do an individualized review. Look at what this person's situation is, what's going on. Are they covered by FFCRA or not, based on the circumstances at hand? Look at the reason as to why they need FFCRA. Is there interplay with regular FMLA leave? So that's why it's really important to look at each person as an individual, because there could be different outcomes from person to person with the same exact problem, but maybe one person has FMLA available to them, the other person does not. Is intermittent FFCRA available under the circumstances? What are the pay caps, which will vary depending on the reasons for the FFCRA leave, as you've seen? What are your existing policies and benefits? Is there an interplay that goes on here to allow an employee to use those benefits contemporaneously with FFCRA leave or not? And what can you be asking, getting back in return to confirm the need for the leave? A lot of these larger issues are something that you should be thinking about right now. But certainly when you are looking at the specific reasons for the individual, you are really tailoring your analysis to the individual in question. Next slide. So just to remember, the FFCRA provides some employee protections. I'm going to be talking about retaliation, but it does allow an employee to return to work, to return to their job. It allows an employee to continue to have healthcare benefits. And we're going to turn to retaliation. There is, in the FFCRA itself, a non-retaliation provision. You can't retaliate as an employer against an employee who needs to use FFCRA leave or who has used FFCRA leave. And that's going to be really critical to remember, because as people are coming off of FFCRA leave, as people are needing to use it, your interactions with them may be misinterpreted as retaliation if you don't have in mind some red flags to be thinking about. Not going to happen all the time, hopefully not ever, to the employers in the group, but something to bear in mind, that there is an individual non-retaliation provision in this law, like many others that we're going to turn to in a minute. Next slide. So before we get to retaliation issues, something else just not to forget, the fact that we're in this unprecedented landscape doesn't mean that some of the things that we have been used to have gone away or changed. COVID-19 and the FFCRA and where we find ourselves today has not changed the legal prohibitions against employment-related discrimination, harassment, or retaliation. And what we have seen is the EEOC in particular has got some great guidance and updates out there about how the COVID-19 pandemic situation impacts, interplays with some of the other existing discrimination or retaliation or harassment laws, such as national origin or race discrimination. At the beginning of the pandemic, you may recall there were discussions about other countries before the pandemic really hit the US, and about avoiding perceptions or discriminatory issues because of where a person came from or where a person had traveled from. Age discrimination, it still remains in play. Not making assumptions about an employee due to their age, making assumptions that they're must be in some high risk category. So you are doing things differently with that employee than you would do with anybody else. So not to lose sight of those issues. Disability discrimination always remains an issue. Thinking about how if an employee has COVID-19 issues, how that interplays with an overlap of disability discrimination concerns, disability considerations such as reasonable accommodations, not losing sight of those issues. Not forgetting that we need to be mindful about the existing FMLA law, about no interference and no retaliation for somebody exercising FMLA rights or FFCRA rights. And also be mindful about the concepts that continue to exist about disparate treatment or disparate impact related to who you are. And that can happen in any number of ways, but it also can happen in terms of layoffs, furloughs, return to work. Why are you selecting the people you are selecting to return to work or to be included in a furlough or a layoff? Those considerations should always exist, but with the issue of COVID-19 and people being out in much greater numbers than in the very recent past, those issues continue to be at the forefront. Next slide. So to talk about retaliation. Retaliation can come in a lot of forms. Again, this is nothing new, but just something to be thinking about and reminding yourself about. I'm going to, spoiler alert, I'm going to talk at the end of the presentation about this could be a great opportunity for you as an employer to train your employees, particularly your supervisory employees and managers, about concepts of retaliation. But retaliation can come in many forms. It could be a reduction in somebody's hours. It could be a change in job duties. It could be, for instance, a classic case in retaliation involved an employee who needed to work a particular shift due to childcare issues, and the employer changed the shift to a third shift, which was a real hardship for that person. Change in your job duties, a reduction in your job responsibilities, or assigning duties that are disfavored. A denial of opportunities, denial of training or promotional opportunities, demotion. Discipline. It doesn't have to be termination, although you see that on the slide. That's the ultimate form of discipline. It could be discipline such as a suspension or a write-up, termination of employment, or inclusion in or extension of a furlough. So I'm included in a furlough as an act of retaliation, or I could have been brought back and I'm not, as some form of retaliation. So the next slide. So in addition to the FFCRA, we also need to be thinking about retaliation on other fronts that can overlap, including the Americans with Disabilities Act, the disability discrimination piece. We need to be thinking about the FMLA. If the FMLA is involved, is going to be an appearance of retaliation because somebody has asked for FMLA leave or is out on FMLA leave, or has recently come back from FMLA leave. We have Title VII of the Civil Rights Act of 1964, which is a federal law that many of you are familiar with, that talks about sex discrimination, pregnancy discrimination as a form of sex discrimination, race, national origin, religion, color, and state laws, many states, including New Hampshire, Massachusetts, and Vermont, have laws that address the same discriminatory areas also address leave issues as well. So when we're thinking about retaliation, although my focus is COVID-19, be mindful that when you're dealing with a COVID-19 situation and an employee, that these other laws could apply. I didn't put the Age Discrimination in Employment Act up there, but that could be another form as well. So please don't lose sight of the very basics that we already needed to observe going into our current situation. Next slide. So the biggest thing I would have you take away from the discussion about retaliation is timing is everything. That and talk to your HR team, please. I'm a huge proponent of employers, managers, supervisors, if they feel that they have an issue with an employee, to please interact with HR before decisions are made so that HR can be helping as a support, identify potential retaliation issues that the manager, the supervisor may have been completely unaware of, but to have that discussion beforehand. Because with retaliation cases, timing gets to be particularly significant. You've probably been at seminars, at webinars, at our presentations, where you've read that retaliation claims are some of the most commonplace claims in employment matters. That remains the case, that hasn't changed. And what we've discussed repeatedly is that what that means as a practical matter is that you could have an employee come to you and they feel that something has happened that is illegal, that they were discriminated against or harassed because of a protected status that they have, or because they engaged in protected activity. And your obligation as an employer is to look into that, to understand what has happened, to respond appropriately, and to make sure that the problem doesn't reoccur if there's any inappropriate conduct occurring to the best of your ability. So many times that whole interaction happens very successfully. You as the employer are working on it very diligently, you're responsive, the situation resolves itself. Life seems to go on and it's a good thing. And in many instances, there could be misunderstandings, there could be unprofessional conduct, but nothing illegal. And you work through those issues really very effectively. But then it's very easy to kind of let things go to the wayside. And it's very important to be following up and making sure that things continue to go smoothly with a person who's brought forward a concern, with people that have participated in that process of looking into that concern, with the supervisors involved, to make sure that the workplace is professional and proceeding in a very effective, appropriate manner. It's very understandable, I think, if somebody who had been involved in such a process, complaining, participating in a complaint proceeding, and something negative happens to them soon on the heels of it, they may make the assumption, perhaps completely incorrectly, that there is some retaliation going on. It doesn't mean that there is. It doesn't mean that there is at all. But it's an honest discussion to be had about whether that is something that is negative is retaliation. So that's why, as an employer, it's very important to be mindful of these considerations so that as you're making business decisions, as you're addressing operational needs and things that come up in your business, you are not inadvertently tripping over a retaliation issue or creating a misunderstanding you didn't need to create about potential retaliation. Next slide, please. So again, I'm a big proponent about a great collaboration, interaction with supervisors and management and HR. And I think it's really important for people when they have a difficult situation with an employee, and for our purposes, we're talking about COVID-19 impacted employees, whether they're out on FFCRA leave or have recently returned or have indicated they need it, or have indicated that whether or not they have that leave available to them, there are things going on with them that are COVID-19 related that you essentially need to address. If you've got some issues with that employee, it's really helpful to draw back and coordinate with HR and talk about where you are. First of all, look at what's the information you have. Is there information that is verified, that you've already looked into, that you can objectively confirm? Or are you getting hearsay information? Are there more questions out there than answers at this point? Do you need to look into whatever the situation is further to get a better understanding about the facts, to understand whatever the problem is, what do you think is going on? Do you have a legitimate business reason for thinking that there's some action that should be taken against an employee? What is that legitimate business reason? Is it a policy or a contract violation, as I have up there? Or are there other things going on? And again, because retaliation can be many things other than discipline or termination, there may be things going on with your business where we need to have a reduction in force. We need to have a furlough. We need to scale back people's hours. We need to change responsibilities because we need to be more nimble in our organization. What are those business reasons going on? And, presumably there are legitimate business reasons, but verify why you are thinking you need to take a particular action. How does an employee that is impacted by an action, be it disciplinary or non-disciplinary, how do they compare to other similarly situated employees? So for instance, particularly in areas of discipline, if you're saying, okay, we need to discipline this person due to a policy violation, due to behavioral issues, due to conduct, okay, let's draw back and think about this. Are we being consistent with how we have treated other people? This person is dealing with a COVID-19 related issue. We're working with them on that issue. How, with what we are thinking the action ought to be, how does that stack up to how we've treated other people who've done the same thing, who've had the same problem, who've had the same policy violation? What is the status of employment records? If you're talking about an action specific to the employee related to discipline or some form of demotion or change in responsibilities, is that well documented? Is this going to come as a surprise to the employee? Or is this going to be something that absolutely you can demonstrate this has been an ongoing problem? We've tried to deal with this. The employee is fully aware of this as an issue. We've had multiple discussions, multiple sit downs, multiple documentation. And this comes as no surprise to anybody that this is an action we need to take. Ask yourself the question, why now? I think we can all understand that if somebody is going through a COVID-19 related situation, is there a need to take a particular action immediately or not? Why does it need to be now? And for instances where the action that you are undertaking as an employer is more kind of a macro operational issue, it absolutely might need to be now. You need to do various things to keep your business running. You need to make cuts to people's hours. You need to realign responsibilities or do other things just to keep you operational, keep the lights on, keep your product going out the door. But think about that and think about, is it really necessary to do whatever I'm thinking about that might impact this employee right now? The answer may be yes, but at least you've thought about that. And is there any different action possible to avoid a perception of retaliation? So for instance, maybe you do have an employee that has just done something that is inappropriate. But maybe you have a range of responses that you could have, and you're going to opt to do something that is more counseling or more educational versus something that is disciplinary. The big point here is that it's very important, I think, to be thoughtful in understanding that when you have someone who is in a situation involving COVID-19, it may be implicating a variety of laws that have non-retaliation provisions. And so you're making a thoughtful decision. You're making a decision that's based on your legitimate business needs, and you're not doing something lightly. You're just being mindful about how you are approaching the issue and the person. Next slide, please. Again, a little full Lawyer Employment Act dig, if I could. If you do have the ability to work with in-house counsel or lawyers who generally represent the company, this is a great time to pick up a phone and have a discussion privately, attorney-client privilege, before communicating any action. It's just another sound way to go through a process, and those discussions can be very effective to kind of head off trouble or just approach a problem in a way that is fair to you as the employer, fair to the employee as well. Next slide, please. And again, consider employee training. Many supervisors, managers are not, they're wonderful at what they do, but they are not hired to be HR representatives. They're hired to do the job that they're hired to do, and they're great at it. But it's easy in all the work that is being done in trying to keep things on track during a pandemic to be focusing on putting out fires and maybe not be mindful of some of the things that you ought to be mindful about in terms of actions taken with employees. It is very helpful to, in addition to coordinating with HR before any action, to give your managers some refresher training about retaliation, about discrimination, about families first. And again, my advice has been consistently, in my mind at least, that the training is really to educate those managers, to help them understand what is out there, what are some red flags, what your policies are, what their obligations are, but also to help them know, okay, I'm hearing something from an employee, they have a particular need, they have a particular concern, it's COVID-19 related, what am I doing to engage HR as quickly as possible in that discussion, in that analysis, and make that handoff. Nobody's expecting a supervisor or manager to be an expert at everything, but it's great for them to know what your policies are, what the FFCRA is, what the expectations are about how they can coordinate effectively with HR very quickly to address issues as they arise. Next slide. And those are the formal discussion for the day. I do see some questions and answers, which I will do my best to try to address. Let's see here. A good question is, and I'm sorry if I'm squinting and looking very closely at the screen, but I will try to address the questions as they come in. One person had asked, what types of injuries might one sustain at home other than ergonomics? If someone tripped over a rug at home while going to the bathroom, for example, would that be something considered workers' comp? I think that's a great question. And I think it does come back into, what they were doing at the time and where they were doing it and what they were in the midst of doing. So for instance, I think those specifics would be scrutinized very carefully, situation to situation. So somebody, getting up and they're in the process of making a copy at their home copier and they slip and fall, is that really any different than if they were doing the same thing on site versus somebody, getting up to get a snack at 8:30 at night as they're watching TV, just because they were in their home, that doesn't convert it to a workers' comp injury. So the answer is, I think it will be very fact specific, and it will be helpful to you to kind of have set those parameters so that there's something that you can refer back to versus trying to address those issues for the first time. The next question is, how do we handle job workload when an employee is extensively out on FFCRA when tasks cannot be reassigned? Do we hire? If so, what happens when the employee is no longer using FFCRA? great question. The employee does have a right to return to their job from their FFCRA leave. So I think that if you, and there may be, depending on the circumstances, the employee has some ability to work intermittently while using FFCRA leave. It doesn't sound like that's what the question is talking about. So if somebody is out, is truly out, and they need to be out extensively, I think that really comes back to what would you be doing if they were out on an extended leave, on FMLA leave, on maybe an ADA leave of absence. If you need to have somebody come in and do the work, there needs to be an understanding that that person who is out on a protected leave has a right to get their job back. So it doesn't mean that the work doesn't need to get done, but it does mean that they need to have their job back when they're ready to get back to it. Let's see here. I'm going to keep reviewing these, so if you just bear with me for a minute. This person has an employee who's out earlier this year on FMLA. She's now out on the FFCRA to care for her son. There's some specific situations that are being addressed in this question that I'm not going to repeat, just because it might get a little bit of a personal identifier. But I think where the question is how are you balancing and taking into account the FMLA and FFCRA. The FMLA provides the amount of leave completely possible for the employee. If they are out on FFCRA, it counts into that amount of FMLA leave of 12 weeks available to them. So it is something that you're going to need to be monitoring, that they may run out of the ability to take the extended family medical leave. The employee may run out because of FMLA leave previously used within the measuring time period. That's why it's important to be keeping track and having this be an individualized assessment, because you could have two people in your company, both have kids in the second grade at the same elementary school with the same needs, and one person may have a different outcome than the other, depending on, assuming you have FMLA available to you as a company, depending on the person's FMLA use within the measuring time period. I know that's generic, but I think that's the general principle to take away, to be concerned about the individualized assessment. So I think what the next question is about is the discussion about perhaps remote work. It is along with the policy. Should there be a document the employees and supervisors sign? If so, what should it look like? I do think it's helpful to have a separate document. The policy is going to give somewhat of an overview of the expectations of the employer concerning remote work, to have that flexibility to continue or discontinue it or modify it as you need. I think the document that the employer supervisor or HR or whoever is the appropriate signatory and the employee should sign is really taking those concepts and getting more specific about hours of work, about what equipment will be provided, about what will be reimbursable expenses or not, about the expectation of where the work is going to take place, about the expectation of availability and communications. Some of those things we have just discussed, about the fact that the employee is still expected to adhere to your policies and to behave appropriately. Just because they're remote working, they don't get to start to violate your discrimination policy or to do things that would not be appropriate if they were in the office. So I think that separate document is something that can be a pretty streamlined, not overwhelming, but effective document to have the employer and the employee review and sign, just to lay out the expectations. It isn't an employment contract. It doesn't mean that the employee is not an employee at will, if that's the case, but it does help people know what the rules of engagement are for one another. The next question is, Some positions in our office are able to work remotely while others are not. Should we be concerned with fairness in deciding whether or not to let someone work remotely versus using FFCRA? I think, I guess I would rephrase that a little bit. There are definitely issues and perceptions of fairness sometimes, but there may be many jobs where you simply, remote work is not an option, or at least complete remote work is not an option. You know, you need to be on a manufacturing floor. You can't do that from home. You might be a first responder. You might be an essential employee in terms of the work being done in the organization. You know, somebody needs to be on site to do various things, or we're not going to be able to function. So to some extent, there may always be jobs that will lend themselves to remote work, and there may be jobs where it just isn't going to be feasible. That may not be perceived as fair by some, but as long as I think you have a legitimate business reason to be saying, no, you know, we're sorry, but this job, you need to be on the production floor. We need to have you there. That is not something that you can do from home. I think that is certainly an understandable, legitimate business decision. If somebody thinks that's unfair, perhaps they're not really thinking it through enough, you know, from the perspective of an employee. If somebody, so I don't think the issue is, can somebody use FFCRA or not? If somebody is eligible for it, has a need for it, that is available to them. The question is, are they otherwise able to work remotely? So I don't think it isn't that you're kind of picking and choosing who uses the FFCRA leave. I think more the issue is you're appropriately determining who can work remotely. And it may be that although you don't have a system in place where that particular person is working remotely, but that can be an accommodation to them for a limited circumstance because of what's going on with their particular needs. So just bear that in mind. Remote work may be something that can be an accommodation to the person. And do bear in mind that the FFCRA presumes that the person cannot be working, including remote working, because of a COVID-19 related issue. So I think you're looking at who can remote work. You're looking at, does somebody who otherwise normally wouldn't remote work, do they need to do so for a period of time? Can they do so as an accommodation? And if remote work isn't possible, is that person eligible for FFCRA leave? It does get intertwined, but I think the two can be distinct concepts that you may be talking about, but you can have FFCRA leave and still be a person that normally may be able to remote work, but perhaps they're so ill they can't do so at that point. Just be thinking that the two are not an automatic equation with one another. Let's see here. Are there restrictions regarding remote work from another state? For example, the employee wants to work remotely from their camp in Maine when the employer is located in New Hampshire. I think there's a couple things going on there. One is, are there state emergency laws in place that would somehow impact that situation in terms of your workplace? And do they, or does it really not terribly make a difference? If you have somebody that is able to work remotely and that is going to be a situation for you that's going to go on indefinitely, and you're fine with that, I think you can be talking with the employee about, again, where is that remote work going to take place? Is that appropriate under the circumstances? If, however, you may have a situation where you need to have the employee come back into the office and their choice of where they work would impact their ability to do that because of guidance about quarantining or other restrictions or other simple logistics, you may be talking with them about, no, look, the remote work arrangement we're foreseeing is gives you the ability to perform the functions of your job within that arrangement. And there may be some components of what you're suggesting here that give us pause that you're not going to be able to do that. For instance, if they said, I'd like to, this is separate from this question, but just by way of an example, they were saying, I would like to remote work, or you would like them to remote work. And they're saying, I really am a night owl. I really want to work from 10 p.m. to 6 a.m. I think you might likely say, well, depending on our business needs, that's not a good fit because we need you to do X, Y, Z, and the rest of your team or our customers are available during some other core business hours. So that's not a good fit. Or it might be a perfectly good fit. So I think that question really does come down to looking at what is proposed and if it truly makes a difference. And then the question is, what if the state doesn't require quarantine, but your work does? So if I go to my private residence in another state and that's not the state mandated to quarantine when you return, but my work makes me, again, I think that is going to be depending on trying to balance those workplace needs versus whatever is the current, operative word, current guidance from the various states. We've seen it change. We've seen it change quickly, and we've seen it, go from in New Hampshire, 3 states to the New England states. There's a lot of changes that go on. So I think that you are talking employer to employee with what does this remote work arrangement look like? Are there any concerns about it being not a good fit under the circumstances because what the employer's expectations are in relation to what the employee may want to do? I think that is a discussion to be had. And in some instances, it may make no difference at all. And in some instances, it may make a lot of difference. But I think that's a fair discussion to be had because at the end of the day, what is trying to be done here is that employers and employees are trying to keep the businesses running, keep the operations going, everybody keep their jobs, everybody stay safe and healthy. So that doesn't change. And some of these conversations may have points that make it less effective or perhaps not effective at all that need to be discussed with the employer and the employee. And again, I think that it's a two-way street. I think the employees ought to be understanding that ultimately the employer needs to stay in business and be making some good business decisions about what remote work looks like under the circumstances and whether it makes sense for the position in question. And so I think that's the end of my presentation today. I really thank you all for being here on such a busy day. I wish I could see you all like we would do before all this happened, and I look forward to that time. But thank you again.
Thank you, Liz.